Welcome back. Today, some legal and ethical issues, specifically the overarching issue of understanding antisocial behavior in light of abnormal psychology, as explored through the subordinate issues of psychopathy, schizophrenia spectrum disorders, and criminal and moral responsibility in Canadian courts of justice. First, since this lecture attempts to bring things full circle, a review from Lecture 1. When seeking to convict someone of a crime, it must be established that their body committed the crime, beyond a reasonable doubt, but also that they were of evil mind at the time of the crime. Put another way, true crimes require moral blameworthiness. The mens rea component of a trial is establishing that a blameworthy decision was made. In other words, a normal person with a normal moral compass would not have made the decision that the accused made, or at least beyond a reasonable doubt made. Therefore, the individual is guilty. Not just of physically committing a crime, but of mentally making the wrong choice. The place where the requirement for mens rea is likely most clearly enshrined in our Canadian Criminal Code is in Section 13, which states that no one under 12 can be criminally responsible for any committed or omitted action. If a 10-year-old intentionally grabs her father's rifle and intentionally shoots him multiple times with that rifle, she is not, in the eyes of the law, morally blameworthy, because the law has decided, in black and white, that at age of 10, she can't understand what she's doing. She can't understand the consequences well enough to be considered morally blameworthy for her action. You can, of course, argue in court that the 10-year-old should be seen as morally blameworthy. The point is just that enshrined in black and white is the fact that the court is probably not going to find her morally blameworthy. The court would have to first decide that the girl was abnormally, for a 10-year-old, aware of the consequences of her actions, and then that with that awareness, she made an abnormally immoral decision in shooting her father. Without imagined normality and expectations of how responsible adults would behave, there is not much left of the law. It requires the imaginary normal person, which brings to mind great critical questions like, what is the expected intelligence level of the normal human that the law imagines? Is the normal person more male, more female? And what moral or ethical values are we presuming, or may we presume, that this normal person holds? Now, this standard of the normal expectable person can be applied in different ways. The one that requires the most mind reading is called subjective mens rea. When we actually have good evidence regarding the intentions of the individual, then we've established subjective mens rea. If right before committing a crime, you texted a bunch of people or posted on a message board that you were going to do it and that you wanted to do it and that you're doing it on purpose, and maybe afterwards you post about how great it was, we have subjective mens rea on you. As long as we can establish there's no reason to think that you were framed, then we can infer that you did in fact have evil intention. The question before the court is, have we established that you intended the consequences of your actions, or that you at some point could have realized or probably realized the consequences of your actions, but you proceeded anyway, or maybe that you were willfully blind, where willful blindness is not wanting to think about or consider the consequences of your action. Remaining ignorant of the consequences of your behavior, but deliberately so, not inquiring when a normal person would have inquired as to what consequences their behavior might have. One place where willful blindness might come up is in criminal harassment. Do you constantly mock or make sarcastic or serious sexual comments about one of your coworkers? Where this happens, it's often the case that the perpetrator will justify it as humorous or good-natured. So in that case, it doesn't seem like they intended harm, but if they in fact contributed to a toxic environment, it could be argued that the individual is responsible, not because they intended to harm the individual, but because they were willfully blind as to the need to inquire as to whether the individual was being harmed. In other words, a reasonable person would have stopped and asked, "Are you okay with me or us poking fun at you? Is it still all fun and games? Or do you need us to stop with these jokes or put downs or sexual comments?" If the court can infer that a reasonable person would have inquired, then a lack of inquiry shows a failure to live up to the standards of a normal, reasonable person, and therefore shows moral blameworthiness for any harm caused by this alleged criminal harassment. I dilated on willful blindness in part because subjective mens rea presents us with a problem that willful blindness makes a bit obvious, and that problem is mind reading. How do you know that the person who's doing the harassing was willfully ignorant versus just ignorant? From what do you derive knowledge of their will? The version of mens rea that does not involve this level of mind reading is called objective mens rea. It doesn't ask what should we infer beyond a reasonable doubt that the accused willed or desired or intended. Rather, it asks only what would the reasonable expectations for this human have been in this situation. What standard of care could we have expected them to follow? Roy was driving in the fog, and he went to turn from a gravel road onto a busier street. He was turning left, but through the fog came a large truck. It hit Roy in the passenger side and killed his friend, who was in the front passenger seat when Roy was driving. So he was in a terrible crash, and he lost his friend, and then he's up on charges for not driving carefully. And the initial determination was that Roy was guilty of not behaving according to the standard of care, guilty for the death of his friend. But one of the things established in his trial was the lack of visibility due to the fog. So on appeal, it was a rather simple question of what could be expected of a normal person in this situation. Humans can't see through fog, and parking randomly on the side of the road might not necessarily be a good idea. What would a reasonable person have done differently? So on appeal, it was decided that Roy wasn't guilty of the death of his friend. But note that the crux of the case here is what would we expect from a normal person? Not an overly anxious person who would pull the car to the side of the road, but a normal person. Now, if you're wondering how an objective comparison to Roy with an imaginary normal person would establish that Roy had an evil mind at the time of the incident, an answer comes from Cromwell, namely that establishing objective mens rea brings with it the presumption of a subjective fault on the part of the individual. They were, after all, the ones driving their own body at the time. But of course, the neat distinction between subjective and objective mens rea is not always so neat in reality. Often cases will involve both objective and subjective components, such as the Alberta hatchet attack case. Friends were drinking, and one of them attacked the other with a hatchet. Her defense was, "I was so drunk that I couldn't possibly have known what I was doing with that hatchet." And here's the judge focusing our attention on what's actually being decided in the case. I don't know about you, but in this quote, I read a lot of sarcasm. What's being decided is whether the evidence here, if believed, could reasonably support the inference that Point, the hatchet wielder, was too drunk to know that 15 forceful blows to the back of the victim's head with an axe or hatchet would likely cause serious bodily harm or death. Is there ever a situation where anyone could possibly be too drunk to know that 15 axe strikes to someone's head would harm them? The question of whether we're assessing subjective or objective mens rea here is rather moot. We're kind of establishing both. One of my favorite details about this case is the fact that we actually didn't end up needing to answer this question because she contradicted her own defense, specifically when she was being interviewed for her description of events. She prefaced her testimony by saying that she hadn't drank that much and she was still quite able to recall what happened on that evening. Her defense was not successful. But wait a second, does that defense ever work? Can you ever say you were too drunk to be morally responsible for your actions? Well, yes, and this is one of the cases where we took a look at that and we decided, well, we actually don't like that loophole in the law, that you can be too drunk to be morally responsible. In this case of R.V. Davio, an older woman was the victim in this case. She was in a wheelchair. At the end of a date, she said, "Okay, I'm going to the other room to go to sleep." And he, who had just opened a bottle of alcohol, said, okay, I'm going to be in here drinking it. And at some point in the night, he entered her room and raped her. And his defense was, I drank the entire bottle of alcohol. I don't remember doing this. So I must have been too drunk to be in my right mind, i.e. too drunk to have a guilty mind. And the reason why this case led to a change in our criminal code is that by following precedent and adhering to the law as it's written, Davio was acquitted. It was established that he was too drunk to be responsible for raping the woman, causing reasonable people to say, we don't like that. Let's change the code. Let's change the criminal code. So they did. Section 33.1 now reads, it is not a defense by reason of self-induced intoxication to say you lacked intent or voluntariness to commit the offense. It can still be a factor that's taken into account, of course, but if you intentionally got yourself intoxicated, you are responsible for what you do in that intoxicated state. As a thinking example, you could take drunk driving. If we accepted the idea that you could be too drunk to be morally responsible for something, then if you're buzzed and you want to drive home, well, you should actually get a little bit more drunk before you start driving. That way, if you do get in an accident, you're not morally responsible for the accident. Yeah, that doesn't scan. We shouldn't allow that to happen, right? So the way the law works is you are morally responsible for getting yourself into the state of drunkenness. We acknowledge that you may not have intended to hit someone with your car when you were driving drunk, but you are morally responsible for getting yourself to the level of intoxication that led to you hitting someone with your car, so you're not off the hook. You're morally responsible. At the risk of giving you too many examples in a legal context, the Canadian courts recognize something called automatism. This is the idea that you may have, as a body, committed a crime, but that body may not have been driven by you. So think sleepwalking, or in terms of the etymology of the word automatism, really good hypnosis. The court divides up defenses of automatism. That is, if somebody says, I'm not morally responsible because it wasn't me driving my body, the court wants to know whether you are arguing for insane automatism or non-insane automatism. Now, the court views insanity in terms of risk. So you would be arguing for non-insane automatism if your automatistic state was a one-off. In other words, the loss of control is not something that regularly happens to you. It was just something that happened in that moment. So if you had a stroke, or you were hit by a baseball bat, or you were given a mix of pharmacological agents that made you sleepwalk, these things could fall into the non-insane automatism category. In other words, the defense is you weren't in control of your body, but that lack of control is not a recurring feature of you. So from the court's perspective, you are not at risk to continue or repeat the automatistic actions that you committed. So the court is free to say, not guilty. In other words, your body committed a crime, but it's been established beyond a reasonable doubt that it wasn't you in charge, some sort of organic change that led to you not being in charge of your body. Therefore, A, you're not responsible, and B, the court doesn't see you as a recurring risk because it was a one-off, non-insane automatism. The court can simply say, not guilty, and let you back out into the world. Contrast that with insane automatism. Once again, from the court's perspective, insanity is a measure of risk. If you're arguing for insane automatism, the argument goes you weren't in charge of your body, but it's a recurring problem, usually a psychiatric one. So maybe you have dissociative disorders, maybe you have somnambulism, i.e. sleepwalking. If it's established that beyond a reasonable doubt you weren't in charge of your body, and in this case you weren't in charge of your body as a function of a regular problem, a regular insanity that you have, then the court will find you not guilty, but since the automatism is tied to a recurring state, the court may need to do a bit more due diligence in terms of making sure that society is protected from you, so you will be found not criminally responsible on account of a mental disorder, or NCRMD, but this status means that the court could potentially detain you for up to 10 years if you continue to present a risk to others. For this lecture, let's start with a general statement of the problem. We have someone who committed an aggressive act. We want to figure out what should be done in response. While there are rather clear-cut answers in the law, in terms of case precedents and the criminal code, there's an intervening layer between the offense committed and those judicial responses. Mens rea needs to be established, and any factors influencing an individual's capacity for mens rea at the time of the offense need to be brought to bear on the response. Some factors influencing an individual's capacity for mens rea are psychiatric disorders. Taking aggressive behavior as the presenting problem, what psychiatric conditions might we expect to see as possible underlying or explanatory factors? Required for NCRMD, not criminally responsible on account of mental disorder, is an MD, a mental disorder. So, to get started, let's take a look at a differential diagnosis tree for aggressive behavior. While aggressive behavior is a complication of many psychiatric disorders, like ADHD, bipolar, borderline personality disorder, schizophrenia, and schizoaffective disorder, it is a defining feature of a few other disorders, specifically intermittent explosive disorder, conduct disorder, antisocial personality disorder, and disruptive mood dysregulation disorder. Not all aggressive behavior is associated with psychiatric dysfunction, and not all psychiatric dysfunction is warrant for determining reduced criminal responsibility, but let's see what diagnoses we might land on and why. We have an individual whose presenting problem is aggressive behavior. Let's go down our decision tree looking for diagnoses. First, is the aggressive behavior due to the physiological effects of a substance? If yes, is it associated with a disturbance in attention and awareness characterized by a fluctuating course? If yes, delirium of different kinds. We have intoxication, withdrawal, and medication-induced delirium. If it's not associated with a disturbance in attention and awareness characterized by a fluctuating course, then is it associated with evidence of decline in a cognitive domain, for example, memory or executive function? If yes, we have substance or medication-induced neurocognitive disorder with behavioral disturbance, specifically aggression. If it's not associated with evidence of decline in a cognitive domain, then we just have aggressive behavior due to the physiological effects of a substance, so we have substance intoxication or withdrawal or other adverse effect of medication. Substance-related aggression is far and away the most common type of aggression. Intoxication is the psychiatric condition most likely to lead to aggression, especially when in the presence of other aggression-relevant psychiatric conditions. But let's say the aggressive behavior is not due to the physiological effects of a substance. Our next question is it due to the physiological effects of a general medical condition? If yes, is it associated with a disturbance in attention and awareness characterized by a fluctuating course? If yes, then delirium due to another medical condition. If no, is it associated with evidence of decline in a cognitive domain? If yes, neurocognitive disorder due to another medical condition with behavioral disturbance, i.e. aggression. If it's not associated with cognitive decline, is it occurring in a pattern representing a change from your previous personality pattern? If yes, then personality change due to another medical condition with the specifier aggressive type. If no, then we have aggression due to the physiological effects of a general medical condition, so it's some other specified mental disorder due to a medical condition. For these determinations, a recognized medical condition is required. There are some controversial circumstances where clinicians want to assign these diagnoses, but no medical condition has been recognized or diagnosed. Clinicians may, for example, have observed nervous system functioning differences with EEGs or response time tests that suggest something is wrong or different, but they don't have a category for their observations. In this case, clinicians have been diagnosing unspecified condition of the brain and referring to it as the general medical condition. So in the case of this last box, they would have other specified mental disorder due to another medical condition, and that other medical condition would be unspecified condition of the brain. Okay, what if the aggressive behavior is not due to any medical conditions, specified or unspecified? We continue our search for any appropriate psychiatric labels. Is the aggressive behavior occurring in the context of a delusion or hallucination? If yes, you're going to move to the psychotic symptoms tree. If the aggressive behavior did not occur in the context of a delusion or hallucination, then with the aggression, do we see agitation associated with at least two characteristic symptoms of catatonia? If yes, then we have a decision tree for catatonia. If no, is the aggressive behavior occurring in the context of an elevated mood? If yes, we're looking at mania, so schizoaffective disorder or bipolar 1. If no, is the aggressive behavior occurring as part of a pattern of violation of the basic rights of others and of age-appropriate social norms? If it is the individual over 18? If they are, that's antisocial personality disorder territory. If they're under 18, that's conduct disorder territory. Note that for the first 3 diagnoses, the aggressive behavior is not characteristic of the disorder, but it can be a complication of it. While for the latter 2, antisocial PD and conduct disorder, aggressive behavior is characteristic of the disorder. What if we have not yet said yes to anything other than aggressive behavior is present? We continue our search for any appropriate psychiatric labels. Is the aggressive behavior occurring as part of a persistent personality disturbance characterized by angry outbursts, mood dysregulation, and identity disturbance? If yes, borderline personality disorder territory. If no, is the aggressive behavior occurring in the context of severe temper outbursts that are grossly out of proportion to the situation, accompanied by persistent anger and irritability between outbursts? If yes, disruptive mood dysregulation disorder. If no, is the aggressive behavior occurring in association with a pattern of argumentativeness, defiance, and vindictiveness? If yes, oppositional defiant disorder. And if we've not yet said yes to anything other than aggressive behavior is present, then we continue our search for any appropriate psychiatric labels. Is the aggressive behavior occurring in association with persistent symptoms of hyperactivity, impulsivity, and inattention? If yes, is it occurring in at least 2 different situations and causing clinically significant impairment, with several symptoms present before age 12? If no, then is the aggressive behavior occurring in reaction to attempts to separate the individual from major attachment figures? If yes, separation anxiety disorder. If no, and we have not yet said yes to anything other than aggressive behavior is present, we continue on our search for any appropriate psychiatric labels. Is the aggressive behavior occurring in association with persistent deficits in social communication and social interaction, accompanied by restricted, repetitive patterns of behaviors, interests, or activities? If yes, autism spectrum disorder. If no, is the aggressive behavior occurring in association with deficits in intellectual function, with accompanying deficits in adaptive functioning and onset during the developmental period? If yes, intellectual disability. If no, is the aggressive behavior occurring in the context of episodes of aggressive behavior that are grossly out of proportion to the situation? If yes, intermittent explosive disorder. If no, we still have not indicated yes to anything other than aggressive behavior is present. We continue our search for any appropriate psychiatric labels. Next, we have the explicitly stressor-induced disorders. Is the aggressive behavior occurring in the context of symptomatic response to a psychosocial stressor? If yes, is the stressor extremely traumatic, for example, life-threatening, and is the individual re-experiencing the trauma? If yes, PTSD or acute stress disorder, depending on how long it's lasted. If no, it's just aggressive behavior in response to a psychosocial stressor, so it's adjustment disorder. If the aggression's not occurring in response to a psychosocial stressor, is it clinically significant aggressive behavior not covered above that the clinician believes is indicative of a psychological dysfunction in the individual? If yes, your only remaining category is unspecified disruptive impulsive control and conduct disorder. If it's not clinically significant aggression or not indicative of psychological dysfunction, then you just have non-psychiatric aggressive behavior. Note that in this case, the phrasing is not normal aggression, but rather non-psychiatric aggression. Recalling that psychopathy is, by DSM-5 standards, a more extreme specified version of antisocial personality disorder, as we just saw, aggression associated with antisocial personality disorder is psychiatric aggression. So in principle, someone could argue for an NCRMD verdict if they meet criteria for antisocial PD. It is, by DSM-5, a mental disorder. First, let's look at whether that diagnosis would be enough. Then we'll look at relevant assessment criteria for that diagnosis. Is a DSM-5 diagnosis enough for a verdict of not criminally responsible on account of mental disorder? The short answer is no. An illness, which is a term generally interchangeable with disorder, is of course required for a mens rea defense, but it's not sufficient. This illness needs to have been a factor at the time of the actual offense under consideration. If I have somnambulism, but I assaulted someone for taking my barbells at the gym, the disorder is irrelevant. Likewise, if I have a psychotic disorder, but there's reason to believe that I was in my right mind at the time of the offense, the disorder may likewise be seen as irrelevant. Moreover, the Venn diagram of illnesses recognized by the DSM and illnesses recognized by the court has portions of both circles in non-overlapping space. Any given court is free to not consider intermittent explosive disorder an illness, and any given court is free to create its own case precedents identifying illnesses not recognized by the DSM. Canada's recent consideration of the defense of sexsomnia in a 2011 rape case where the offender reported being asleep while raping the victim is a case in point. Sex while sleeping is not a recognized specifier of any sleep disorder in the DSM-5, but the courts could nonetheless have recognized it as an illness that makes the offender not criminally responsible and set a precedent that future cases could use. No court is beholden entirely to the DSM or ICD in what it considers a mental illness. The current movement in psychiatry is to push for medical interpretations of capacity for responsibility. Each case involving a mens rea defense has to reinvent or re-explain the idea of qualified free will and its relevance. The bottom line from the biomedical side of things is, was the person in a psychotic state a break from reality, and can this reasonably be seen as the reason for their action? If you read the quote framed in red, it may cause some concern, since she's criticizing the fact that jurors are using their own, quote, moral convictions. Isn't that the point of juries? But the motivation for her argument becomes clear when she presents cases like that of Andrew Goldstein. In January 1999, Andrew Goldstein pushed a 32-year-old woman in front of a New York subway train, killing her. Goldstein was charged with second-degree murder. Goldstein had a long history of mental illness with well-documented indications that he suffered from schizophrenia and delusion. In 1992, Goldstein committed himself to a state psychiatric hospital where he remained for 8 months before being transferred to a group home. After his release from the state hospital, for years, Goldstein was in and out of hospital emergency rooms begging for additional help, repeatedly. He was turned away and put on wait lists for permanent hospitalization. Records show that Goldstein was labeled severely schizophrenic, thought disordered, delusional, and psychotic. The subway push occurred only 3 weeks after his most recent release from the hospital. Goldstein pleaded legal insanity, but the judge refused the defense and convicted him. He was sentenced to 25 years to life in prison. One juror stated that Goldstein must have known what he was doing because the push, quote, was not a psychotic jerk or involuntary movement. Presumably, something about the expert testimony or judge's instructions got the jury members on the wrong track. If the mens rea defense does not apply in this case, someone who clearly needs psychiatric care, then it's difficult to imagine in what case it would apply. It sounds like this jury member would have accepted nothing short of a Tourette's-like physical tic as qualifying for a mens rea defense. So the convincing side of the case for a biomedical interpretation of criminal responsibility is that some verdicts are clearly wrong. And Beatrice Maidman is arguing that a biomedical approach that simply remembers these two facts, that we need an active state of psychosis and the psychosis has to be linked to the crime, would not get those cases wrong. The insanity defense did not work for Andrew Goldstein. We know that this is the typical result when the defense is used, which is in less than 1% of criminal cases. It tends not to be successful. Successful acquittal was the result of just a quarter of cases surveyed by Stedman et al. In 1993. They took data from 49 counties in 8 U.S. states from cases heard between 1976 and 1987. Stedman's U.S. statistics from cases tried before most of us were born are likely in your Canadian Intro Psych, Forensic Psych, and Abnormal Psych textbooks. For Canadian data, we have the observation that 0.08% of criminal court cases result in at least one charge with a successful verdict of NCRMD, meaning the decision arrived at was NCRMD for at least one of the charges laid. Not present here is how often the mens rea defense was used or attempted, i.e. the failures are not listed here. So this does not give us success rates, but it shows, like the older US data, that NCRMD verdicts are rare. The type of charge for which the most NCRMD verdicts were given was major assault, followed by uttering threats, weapon offenses, common assault, which means assault not causing bodily harm, other crimes against the person, and criminal harassment. Note that many of the crimes would result in less than 3-year sentences, but the mean hospital detention time after NCRMD verdict is around 3 years. In many cases, individuals are spending more time confined in psychiatric hospitals than they would have in prison. A successful NCRMD verdict results in either absolute discharge, conditional discharge, or hospital detention. An NCRMD verdict is not a guarantee of freedom, but it does generally mean the accused will get access to care. Back to psychopathy, the more severe subtype of antisocial personality disorder for which aggressive behavior is characteristic. What would it take to get a diagnosis, and would it qualify for NCRMD? First, a note that antisocial PD is not just a personality disorder. Much like schizotypal is listed in the personality disorders and the psychotic disorders sections, antisocial PD is listed in the personality disorders and the disruptive impulse control and conduct disorders section. It's right before pyromania. We have our general description. Antisocial PD, a pervasive pattern of disregard for and violation of the rights of others. Psychodiagnostic manual's insights. Characteristic belief about self, I can do what I want. Belief about others. Everyone's selfish, manipulative, dishonorable, and or weak. And central ways of defending are reaching for omnipotent control. What I say is, about 3% of males and 1% of females will qualify for this disorder, which is most commonly comorbid with narcissistic PD. And despite the fact that psychopathy is a rarer subtype of antisocial PD, when we test those imprisoned in Canadian institutions, 15 to 25% of them meet threshold for psychopathy. Note that the DSM calls it antisocial PD, the Psychodiagnostic Manual calls it psychopathic personality, and the ICD-10 calls it dissocial personality disorder. A personality disorder characterized by disregard for social obligations and callous unconcern for the feelings of others. There's gross disparity between behavior and the prevailing social norms. Behavior is not readily modifiable by adverse experience, including punishment. There's low tolerance to frustration and a low threshold for discharge of aggression, including violence. There's a tendency to blame others or to offer plausible rationalizations for the behavior, bringing the patient into conflict with society. And here are your diagnostic criteria in the main body of the DSM-5. A pervasive pattern of disregard for and violation of the rights of others, occurring since age 15 years, as indicated by 3 or more of the following. Failure to conform to social norms, deceitfulness, impulsivity or failure to plan ahead, irritability and aggressiveness, reckless disregard for safety of self or others, consistent irresponsibility, lack of remorse. Individual must be at least 18 years of age. If under 18, then conduct disorder. You need evidence of conduct disorder before age 15, and you need to rule out other psychiatric sources of the behavior. In items A7 and A2, we have lack of remorse and deceitfulness. In the ICD-10, this was described as callous unconcern for the feelings of others, and it's what tends to be most surprising or shocking when we see the more extreme cases of antisocial PD. Take this quote from Janine Jones, who was a nurse. "I'm a very feeling person. You can't help but fall in love with these kids. She was a nurse in charge of infants. We know she killed 2 of them, and we think she killed 12 more. But she's a very feeling person, and she can't help but fall in love with the kids." Here's antisocial PD in the alternative model in the appendix. Difficulties in 2 or more of the following areas: identity, self-direction, empathy, or intimacy. At least 6 out of the 7 traits: manipulativeness, callousness, deceitfulness, hostility, risk-taking, impulsivity, and irresponsibility. And if you meet diagnosis, you specify if it's with psychopathic features, which are a lack of anxiety or fear, a bold interpersonal style, and high levels of attention-seeking. Pursuant to the lack of anxiety or fear specifier, a quote from Shea. "It has been suggested that they seldom feel anxiety, and certainly infrequently feel the anxiety born from guilt. Indeed, they live a life in which the superego seems to have never set foot in their psyche. In a surprising sense, these people frequently see their problems as arising from flaws in other people, as opposed to their own inadequacies. They have an almost uncanny knack of convincing others to give them yet another chance, leaving people to feel convinced that this time is really different. It isn't. Obnoxious as these patients may sound, Valent makes the humanizing point that, in reality, they probably do, or at least did at some point, feel pain. Indeed, their amoral behaviors and worldview probably are, at least in part, a reflection of defenses developed to reflect relatively intense pain. For instance, the apparent callousness of their relationships may, in some cases, represent a defense, protecting the patient from a fear of being engulfed by intense dependency needs. Ironically, people with an antisocial personality may very well be as entrapped as their victims, their distancing defenses taking them so far from human emotion that they may appear as monsters, but in the last analysis, they are all too human. But let's not get too carried away with the psychodynamic interpretations. Some of these factors, like low anxiety and callousness, appear to point to a constitutional or biological difference between those with and without antisocial PD. While those with psychopathic traits do fine with cognitive empathy, which is generally mind reading and predicting the actions or intentions of others, they have selective deficits or decrements in emotional empathy, noticing and learning from the emotions communicated by others. If you are high in psychopathic traits, I would predict that you would likely do fine in recognizing anger and disgust in others, but that you would have difficulty recognizing fear and sadness in the facial expressions, vocal tones, and body postures of others. Imagine being even partially cut off from that information, partially cut off from learning when others are sad or fearful, and therefore from learning what makes others sad or fearful. But this recognition deficit corresponds with an activation deficit. Those higher in psychopathy traits tend to have less amygdala response when others are in distress, though it should be mentioned that those high in psychopathy traits tend to have less amygdala response in general, including to being directly aversively conditioned themselves, for example, being punished via shock or a burst of white noise. And it's not just the amygdala. Downstream from the amygdala, fear and sadness in others produces, in those higher with psychopathic traits, less autonomic reactivity, less fMRI blood oxygen level dependent signal, and an atypical or abnormal pattern of EEG response. One can find studies showing cortical volume differences between trait psychopathic and non-trait psychopathic individuals in pretty much every limbic, temporal, and frontal lobe substructure. But the highly consistent findings from high-quality studies, those that, for example, control or adjust for IQ, which positively correlates with cortical volume, show reduced volume in the amygdala, the ventromedial frontal cortex, and the white matter tract that connects them. It was these differences that James Fallon was using to identify psychopathic brains from their brain scans, when he found out he had a psychopath's brain.
I asked the psychiatrists who know me for many years, what behaviors that are not so obvious that I do to people that would be psychopathic. And they asked me about revenge. Am I getting even? Now, everybody gets mad, right? Somebody ticks you off, you get mad. You get mad for 5 seconds, 30 seconds, a minute, up to an hour. Everybody, it's a normal thing. And your serotonin kicks in after about 5 minutes and it cools you down. In psychopaths, it doesn't happen. It stays on boil. It stays on a hard boil. But even though you can control it, you're still angry. You can stay angry for extremely long periods of time. And that is sort of set up in utero because those areas of the brain that respond to serotonin are altered by these so-called warrior genes. So they don't respond when you get older, when the serotonin would have made you calm. And so psychopaths will get very angry, but they'll stay angry. And in the case of mine, what I told the two of the psychiatrists who were very close to me, I said, well, when I get mad, I don't show it to anybody. I said, I could be furious at you. You would never know it. I show no anger whatsoever. I don't show anxiety to them. I said, first of all, you'll never know. And I said, I could sit on it for a year or 2 or 3 or 5, but I'll get you. And I always do. And they don't know where it's coming from. They can't tie it to the event, and it comes out of nowhere. And something dramatic happens in their life. But I'm very careful, almost pristine about it. That's a fair response. It's a proportional response. So if somebody does something, you can do a lot of, you could say anything to me, and I won't get mad, really. Those things don't get me mad. Somebody's trying to get me. It's like another psychopath or another, somebody's trying to mess with me. I have a high threshold, so many things really don't get me mad. You can just about do anything. I'm pretty cool that way. But if you really do, then I always get even. And I'll make sure it's the same sort of intensity that their initial damage. And I said, I can stay cool and it'll happen. And they'll look around, they don't, what happened with their job, what happened with their family, what happened, they won't know. And they both said, that's psychopathic. That's exactly it.
These structural and functional deficits are also what lawyers will occasionally present in court as evidence that their accused clients are in fact victims of their own impulsive frontal cortex and emotionally deficient amygdala brains. The reduced amygdala and frontal cortex volume are found in children with psychopathic traits as well, especially callous unemotional traits, though the reduced connectivity tends not to be consistently found in child research. This means even a small difference could have compounding effects on learning and brain or schema organization. From Chapter 17 of Patrick's Handbook of Psychopathy, appropriate empathic responding is critical for harm-based moral development. For example, for learning to view harm-oriented transgressions, for example, hitting another, as bad. It has been argued that harm-based judgments are reliant on the amygdala transmitting reinforcement expectancy information to the ventromedial frontal cortex. Published studies have demonstrated impairments in moral judgment in youth and adults with psychopathic traits, and other work has shown that high psychopathy youth and adults show reduced amygdala and ventromedial prefrontal cortex activity, along with reduced amygdala ventromedial frontal and prefrontal cortex connectivity when making care-based moral judgments. In addition, youth and adults with psychopathic traits are less likely to judge harm-based transgressions as wrong because they hurt others, and children with higher callous unemotional traits state that they are less concerned, relative to children with low callous unemotional traits, that aggressive behavior will result in suffering in the victim. And high psychopathy individuals show weaker positive covariation between amygdala activity and severity ratings of transgressions compared to healthy controls. So the activity is reduced, and there is a weaker relation between the activity that is there and one's moral judgment. This brings us to the two-process theory of psychopathy. The first process is cortical. One's prefrontal cortex regulates impulsive behavior. This process is disrupted or abnormal in psychopathy. The second process is subcortical. One's amygdala and striatum regulate emotion and motivation. This process is also disrupted or abnormal in psychopathy. While the subcortical processes differ, the cortical abnormalities in psychopathy are very similar to the cortical abnormalities found in those with substance use disorder. From Chapter 26 of Patrick's Handbook of Psychopathy, converging evidence suggests that both psychopathy and substance use disorders are associated with common neural systems, the prefrontal cortex and anterior cingulate cortex, biomarkers, P300 and error-related negativity, and genetic markers. So, we have the following premises to potentially support the conclusion that psychopathy reduces moral blameworthiness. 1, it makes one comparatively blind to the harm one does to others, both in terms of recognizing and empathizing with it. 2, it tends to consistently come with a physically different brain. 3, these physical differences correspond with different understanding and development of the moral substrate that presumably undergirds moral behaviors and expectations. And 4, some of these differences are already associated with differential legal treatment. Specifically, the cortical abnormalities in those with psychopathic traits are similar to those of individuals with substance use disorders. And for the latter, we have drug courts, partly in recognition of their reduced capacity for self-control. There's also the fact that psychopathy exists in every culture where we've looked for it. This would suggest that it is biological, or that all observed cultures similarly create it. The biological psychopath perspective is the most common one in forensic psychology and has been hard won against belief in sociogenic origins. For the psychodynamicists, it was a runaway process of poorly selected ego defenses that was to blame. This left the door open to blame the overattached or the underattached mother, or the absence of a strong father to induce a fear of punishment and therefore produce a superego. The DSM-1 formalized the term sociopathic, which was itself derived in 1930 from the older term psychopathic, and left the door open for interpretation of antisocial reaction as being caused by how society is structured. This, according to some, is what was originally meant by the term sociopathic, but the phrase ill in terms of society is pretty vague. Regardless of what was initially meant, most people using the term sociopath today seem to be referring to antisocial behavior that's not traceable to constitutional or biologically based psychopathy, but rather to poor upbringing. For example, not letting young people experience the consequences of their actions, maybe giving your child the benefit of the doubt too often, believing all their lies, or perhaps blaming sociopathy on pathologically structured societies.
The number one difference between a psychopath and a sociopath starts at the very beginning, at birth. It helps to think about psychopaths and sociopaths like nature versus nurture. A sociopath is a product of their environment, so we put them on the same side as nurture. But a psychopath is born with some kind of genetic or neurological deficiency, so we stick them on the same side as nature.
Well, this all sounds good. It's just pop psychology. There's no recognized diagnostic tool to assess sociopathy, and neither the DSM-5 nor the ICD-10 consider it a separate disorder. The DSM main body mentions both psychopathy and sociopathy just as other names for antisocial PD, and the ICD has them as different descriptors under the same code, dissocial PD, as well. The reason why psychopathy is not subject to the same criticism of just being unformalized pop psychology is the work of Harvey Cleckley and, more recently, Robert Hare. It is Hare's psychopathy checklist and its use in forensic settings that has made the term psychopathy actually mean something. It is the predictive utility of the checklist that has motivated the DSM-5 to include the construct in its alternate model. And if we're going to make a case for psychopaths being not criminally responsible on account of mental disorder, on account of their being constitutionally without a developed conscience, it would have to be psychopaths as they are defined and identified by this test, the only psychopath test that the courts seem to care about. Here's a psychopathy case from Hare's 1993 book Without Conscience. His social status notwithstanding, he's truly one of the most dangerous sociopaths I have ever seen, said the Superior Court judge after sentencing respected 37-year-old San Jose attorney Norman Russell Schonborg for the brutal slaying of one of his clients, from whom he had embezzled money. His third wife, Terry, who initially had provided him with an alibi for the crime, said that when she first met him, quote, he seemed like a nice guy, soft-spoken and exceedingly charming. But she also noted, from the start, Russell spoke about this emotional void, an inability to feel things like everyone else, to know when to cry, when to feel joy. Terry also commented that he led a kind of paint-by-numbers emotional life, and that he read self-help psychology books to learn the appropriate emotional responses to everyday events. As their marriage began to break down, Russell tried to convince his wife that she was going mad. I would go into counseling sessions a basket case, she said, and Russell would sit there calm and gracious and rational, and he'd turn to the therapist and say, see what I have to put up with? And I'd shout and scream and say, it's not me, he's the crazy one. But the counselor bought Russell's act and said we could never make progress as a couple if I blamed everything on my husband. Later, Russell worked out several scenarios for handling his problems with his wife and wrote them down on a piece of paper. Do nothing. File for paternity/conciliation court, take girls without killing, take girls killing for, kill girls and Justin. His probation officer commented that the list revealed the mind of a man who could contemplate killing his own children with the detachment of someone considering various auto insurance policies. It is the laundry list of a man without a soul. Referring to Russell's murder of Phyllis Wilde, his wife said, I saw him just hours after he had bludgeoned her to death. There was nothing in his behavior to betray him. No fear, no remorse, nothing. These are the 20 traits assessed by the psychopathy checklist. The clinician or assessor, using the individual's records, informant interviews, and clinical interview of the individual, can assign for each trait a 0, a 1, or a 2. So the most psychopathic score one could receive is a 40. Some items relate more to deviant behavior, such as criminal versatility, which assesses whether the individual has committed a variety of different crimes. Some items relate more to social emotional ways of being, such as callousness, lack of empathy, and grandiosity. This is called Factor 1, the interpersonal affective aspect of psychopathy. The deviant behavior items comprise Factor 2, the social deviance aspect of psychopathy. The cutoff for psychopathy in North America is 30. It's lower in places like Brazil. Real-world observed inter-rater reliability is not very good for the psychopathy checklist revised. And there are allegiance effects, i.e. whether you want the person to be a psychopath or not tends to influence the scores you give. Despite this, the results of the checklist speak for themselves. Individuals with psychopathy make up about 1% of the population, but are responsible for 44% of on-duty police officer killings. They make up 10 to 25% of people currently in Canadian prisons, at the cutoff of 30. At some prisons in the US, it's 35% of inmates that score 30 or higher. Individuals with psychopathy are estimated to perpetrate roughly 50% of the serious harm-causing crime, as estimated by Hare. They recidivate, i.e. they reoffend and get caught 2 times more often than their counterpart non-psychopathic offenders, and they recidivate violently, i.e. they commit another violent offense and get caught 3 times more often than their counterpart other violent but non-psychopathic offenders. Note that most of the predictive power of the PCLR comes from the social deviance items, the factor 2. The best predictor of future behavior is past behavior. You might think, based on the above numbers, that it's relatively easy for someone who has committed a serious crime, like killing a police officer, to get a diagnosis of psychopathy. That's why I put these items here in front of you. You can see that it's not easy to get a high score on the psychopathy checklist revised. One serious crime doesn't get you very far toward diagnosis. Let's take a case to show how exclusive the Psychopath Club is. John Wayne Gacy grew up in the suburbs of Chicago. He tended to be sick as a kid, and he was emotionally abused by his father, who called him worthless and queer. Gacy held his first job at age 14 at a grocery store and was active as a volunteer as well, but at some point in high school, the verbal abuse from his father made him decide to leave school and run away from home. He went to Las Vegas and got a job in a mortuary, where he was fired from the night shift at the mortuary. How do you get fired working the night shift at a mortuary? Well, if the owner shows up and the cadavers are missing their clothes, that will get you fired from the mortuary night shift. He moved back home, went to community college, got a job as a shoe salesman, and in 1964 married his first wife, Marilyn. Her father owned several Kentucky Fried Chicken franchises, so he gave Gacy a job as a manager at one of them. They had a happy life, a son and a daughter. He had a good reputation, he was active in charities, and he also volunteered entertaining children as Pogo the Clown. He was also having sex with some of the young boys in his employ, and raped the son of one of his friends. The boy told his father, and they went to the police. But aside from searching his house and finding only pornography, nothing else incriminating, the police seemed unwilling to continue with charges because it would essentially be the boy's word against Gacy's, and Gacy was of course a respected pillar of the community. So rather than being charged with rape, Gacy was charged with possession of pornography, which was an offense because it contained images of oral sex, which was, in Iowa, sodomy. When one of his 16-year-old employees refused to perform oral sex on him, Gacy choked him with a chain, and when that boy went to the police, the response was again that there wasn't enough evidence, it was just the boy's word against Gacy's. Gacy denied the event took place and volunteered to take a polygraph test. He took it twice and failed both times. But of course that's not evidence of anything, so no charges were laid. He then conned an 18 and a 15-year-old into performing sexual experiments, paying them for participation in something he called sexual experiments being carried out by the governor of Iowa. At this point, he was finally convicted for the original charge of sodomy due to the pornography, and he was given the maximum sentence of 10 years in Iowa State Penitentiary. At this point, Marilyn divorced him. Gacy was assessed with antisocial personality disorder and with an IQ of 118. And due to good behavior, the parole board granted him early release. Note that this was against the recommendations of multiple psychologists. He started a contracting company and once again was in a managerial position. Gacy was hiring young men to work for his company and paying them roughly twice what the competitors would pay. But some of them were disappearing, and others were being made uncomfortable by things like Gacy's rope game, where he would handcuff the young men and choke them with a rope. One young man who met with Gacy about work disappeared shortly after and had been last seen entering Gacy's van. Rob Peist came from a relatively affluent family that was able to put a little more pressure on police to do something. As he did before, Gacy welcomed the investigators, convinced he could fool them. He invited them into his house, not realizing that they would be able to smell the decomposing bodies of the boys he had killed. Finding one body in a crawl space under the floor, the police proceeded to search the grounds of his house, finding 27 bodies there and 6 bodies buried in other places. His comment when asked how he felt about what he had done, quote, "They shouldn't have tried to con me. I never killed anyone who didn't try to take advantage of me." John Wayne Gacy, one of the reasons why North Americans are scared of clowns, is not a psychopath. These are his scores. He lacks some of the Factor 2 social deviance items, the very ones that best predict reoffending. He scores 29 out of 40, one shy of the North American cutoff for psychopathy. We do not just give away diagnoses of psychopathy. So, those 10 to 25% of incarcerated Canadian offenders that score 30 or higher on Hare's PCLR are all meeting a rather high standard, or high threshold for identification. We have gathered evidence of a difference present in the minds and brains of individuals with psychopathy, a sense of that difference in terms of their experience, and an idea of how that difference is identified. To sort out how this relates to NCRMD, let's quickly address a fundamental philosophical conflict surrounding free will. There is something unsettling and contradictory about deciding how a psychological or biological difference, whether it be permanent or only present at the time of an offense, could preclude criminal responsibility. Taken seriously, the scientific approach is deterministic, and therefore our presumption that we are free to choose our actions is either a quaint fiction or wholly erroneous. Yet this free will presumption is taken seriously by the law. It is axiomatic that we are responsible for the choices we make, that we can make choices and be held accountable for the subjective faults in them. These two perspectives, determinism and incompatibilism, must somehow be reconciled each time a question of criminal responsibility, an incompatibilist free will idea, is addressed by a scientific expert, a determinist, or at least someone whose only job in court is as a representative of determinism. We can, of course, appeal to nuance and case-by-case understanding, but there's an underlying tension between a system built on finding acts of mind responsible for things and a discipline built on finding things responsible for acts of minds. That said, let's see what we have to work with. In the Canadian Criminal Code, criminal responsibility requires that a person be capable, at the time of the offense, of appreciating the nature and quality of the act or omission and of knowing that it was wrong. Note that the absence of either condition, i.e., an inability to appreciate the nature and quality of the act or omission, or an inability to know that the act or omission was wrong, would render one not criminally responsible. The argument, in the case of psychopathy then, would naturally focus on appreciation, and whether to take a narrow or a broad view of the word, because in a broad sense, psychopaths don't appreciate things, like the sufferings of others, the way non-psychopaths do. But note also that if an individual with psychopathy were never told that something was wrong, it could plausibly be argued that they might not be expected to figure it out on their own. In this sense, either of the two conditions could be argued. Psychopathy is eligible for arguments regarding either of the two branches of capacity. Let's look at an older case. In R.V. Kjeldsen, in which Christian Kjeldsen admitted raping and murdering a taxicab driver, Glenda Furster, in Alberta in 1977. The only defense put forward was insanity. Specifically, since there was no doubt he understood that it was wrong, the case was made that he, by virtue of being someone with psychopathy, could not, or not fully, appreciate the harm he inflicted on another human being. Step 1, then, would be establishing the existence of a mental disorder. In Canadian courts, a mental disorder, or disease of the mind, is formally, or by definition, anything, within reason, that a judge decides to call a mental disorder or disease of the mind. If a judge finds it applicable to either branch of Section 16, then a judge may call it a disease of the mind. Let's peek in at the process of determining or establishing disease of the mind in a case. In his defense, the appellant put in issue his sanity at the time of event. Two witnesses, Dr. Irving Wayne and Dr. Keith Pierce, were called by the appellant both of whom were qualified by the learned trial judge as experts in the field of psychiatry. Both were of the opinion that, at the time of the events, the appellant was suffering from disease of the mind and that he could not appreciate the nature and quality of his acts. In rebuttal, the Crown called 3 witnesses, Dr. Jeffrey Hopkinson, Dr. Joseph Pascoe, and Dr. John Brooks. They were qualified by the learned trial judge as experts in the field of psychiatry. They were of the opinion that the appellant did not suffer from disease of the mind and did appreciate the nature and quality of his acts. There was no issue between the 5 experts as to whether or not the appellant suffered from psychopathy. Dr. Wayne and Dr. Pierce concluded that the psychopathy, or personality disorder from which the appellant suffered, should be classified as a disease of the mind. Doctors Hopkinson, Pascoe, and Brooks were of the opinion that it should not. There was a further conflict between the experts as to whether the appellant appreciated the nature and quality of his acts at the material time. Dr. Wayne and Dr. Pierce were of the opinion that he did not. Doctors Hopkinson, Pascoe, and Brooks were of the opinion that the appellant did appreciate the nature and quality of his acts. So, unsurprisingly, the experts for the defense were saying what the defense wants to hear, and the experts for the prosecution were saying what the prosecution wants to hear. Importantly, everyone is agreeing on the psychopathy itself, even if there is argument over Kjeldson's ability to appreciate his actions. The reasons for judgment document then cites earlier precedents implying psychopathy is indeed a valid disease of the mind. In the same year, there were 2 other cases establishing more directly that personality disorders qualify. Note that these cases are prior to 1992, which was when not criminally responsible replaced the original not guilty verdict. Let's peek back in and see how the R.V. Kjeldson is doing. Dr. Pierce's definition of appreciate and his opinion of what the appellant could appreciate is to be found in his direct examination, cross-examination, and re-examination. In direct examination, he said, "Doctor, I would like you to consider hypothetically that the events described in these exhibits took place and that the acts described were done by the accused. Under those circumstances, and at the time described in those exhibits, do you believe that, at that time, the accused would have appreciated the nature and quality of those acts?" No, it's my conviction that he would not have appreciated the nature and quality of those acts. Could you indicate to the court what you feel he would not have appreciated, and describe to the court what you mean by the word appreciate? Certainly. To me, the word appreciate carries with it the implication of being able to completely review and weigh any behavior or series of behaviors proposed or actual, and to be able to understand the consequences of those behaviors in all sorts of terms, human, physical, in every sense. To know something is merely to know it. To appreciate it is to have a full recognition of all its implications. And is it your view that at the time the accused would not have appreciated the nature and quality of the acts? Certainly he had no sense at all of what he was doing to another human being. This rather unproductive exchange is a uniquely Canadian problem. We took the original insanity defense language, just like the United States, from the British 1843 M'Naughton ruling, but we changed something that the US did not. Here's the original M'Naughton ruling. Insanity is an acceptable defense if, at the time of committing the act, the party accused was laboring under such a defect of reason from disease of the mind as to not know the nature and quality of the act he was doing, or, if he did know it, that he did not know he was doing what was wrong. Here's the word know, and here's what we have, appreciate. We changed the word know to appreciate and have been making efforts to substantiate the difference without going overboard for decades. Where we seem to have landed currently is that appreciate implies a fuller sense of knowing, but does not require having the normal feelings associated with that knowing. The requirement unique to Canada is that of perception, an ability to perceive the consequences, impact, and results of a physical act. In R.V. Kjeldson, 1981, the courts affirmed that Kjeldson's defense is not enough. It was unsuccessful in 1980, and in 1981, the court affirmed that lacking normal feelings about one's behavior is not the same as lacking an appreciation, an analytical capacity to understand the physical consequences of your behavior. So we could say of this uniquely Canadian requirement that appreciation doesn't care about your feelings. The door is still open to use psychopathy as one's disease of the mind and argue that it qualifies based on either branch of the Criminal Code Section 16, but the argument would have to be something other than one's lack of a normal emotional life or responses. One could try, for example, impulsivity, which might prevent appreciation in the fuller sense. But we will return to criminal responsibility after a brief look at psychosis. I have had Antisocial PD take up the bulk of the legal and ethical lecture because I think it cuts quickest to one's own core notions of how to build and pursue the good and the good life. It's relatively easy to feel compassion for those with schizophrenia and psychosis, to imagine oneself thrown into their shoes and to advocate for medicine which can at least prevent them from experiencing the more haunting and immediate aspects of their condition, rather than punishment or retribution. In the psychosis context, NCRMD tends to be taken rather uncritically by roughly 90% of my students to be an obviously good thing. Divert from prison to medicine and protect the offender and society. Win-win. Hopefully, considering NCRMD from the more gray perspective of antisocial PD or psychopathy helps you to think about it in more objective, disinterested, or critical terms. There aren't pills to give individuals with psychopathy that make them care about the rights and feelings of others. If you agree, like 90% of my students, that NCRMD is a good thing and have reasons why you think so, then do you think that those reasons why you support NCRMD as a thing include or exclude antisocial PD? And then, from there, you can say, what about anxiety disorders, ADHD, bipolar mania? But now, the relatively low-hanging fruit for NCRMD, psychosis. A psychotic disorder is one marked by the experience of serious distortions of reality. When you hear the schiz in schizophrenia, think schism or split, a split from reality. In the Old Man Logan graphic novel, Wolverine is tricked by Mysterio into thinking the X-Mansion, Xavier's school for gifted youngsters, is being overrun by villains, who start by killing the young Jubilee in an explosion. Canadian courts specifically recognize delusions as presenting a unique situation. Namely, a delusional understanding can preclude a guilty mind because one's understanding of an objectively evil action could be that it was in fact correct and just. If you believe someone is trying to kill you or your family, you're justified to defend yourself. If you believe someone is Satan, an imposter robot, or needs to be cut open to have evil released from their body, and keep in mind that these beliefs are often accompanied by an overpowering feeling of intense urgency, then you did not have ill intent, or at least not the ill intent implied by the actual outcomes of your behavior. So, the content of the delusion matters. If the court can establish, for example, that the defendant could, despite their delusion or delusional state, understand that their action was socially or morally unacceptable, then the defense could not successfully argue a second branch defense, i.e. that the defendant did not know what he did was wrong. Wolverine fought the onslaught of supervillains, thinking he was saving the students, only to find out that the flesh he had been shredding was that of his friends and fellow X-Men, including, in his last strike, the young Jubilee. Wolverine did not know what he was doing. He was not capable of making a rational choice. He was acting under a powerful delusion. Let's start with a case that I know you've heard of. This man. In Manitoba, on the 30th of July 2008, at around 9 p.m., 40-year-old Vince Lee is sat next to 22-year-old Tim McLean on a Greyhound bus with 35 other passengers. The movie Zorro is playing on the bus televisions. Eyewitnesses then report that Vince Lee began calmly but viciously stabbing Tim McLean with a knife. As the bus driver evacuates the passengers and disables the bus so it cannot be driven, Vince Lee decapitates and cannibalizes Tim McLean's body. 4.5 hours later, Vince Lee jumps out of the bus via a broken window and is arrested by the RCMP. 5 days later, on August the 5th, Vince Lee, who has refused legal aid, appears before the judge and says only 3 words: "Please kill me." Earlier that July, Vince Lee had purchased that knife from Canadian Tire in response to God telling him that he would face evil forces on his journey. Vince Lee had, for several years, been hearing God's voice coming from the sun. It had also told him that he was the Son of God, specifically the Chinese Jesus. On the bus, Mr. Lee heard God telling him that Tim McLean was evil, and that Tim McLean would tear Mr. Lee's intestines out of his abdomen if Mr. Lee did not kill him first. During the attack, Mr. Lee heard God tell him Tim McLean would come back to life if Mr. Lee did not remove Tim McLean's body parts, which Mr. Lee then proceeded to do. On March the 5th, 2009, Mr. Lee was found not criminally responsible on his second-degree murder charge. His first branch Section 16 defense was that psychosis, a schizophrenic split from reality, prevented him from appreciating the nature and quality of his actions. Over the next 6 years, Mr. Lee is an inpatient at Selkirk Mental Health Center in Manitoba and gradually earns increasing trust and freedom. In June of 2011, he's allowed outside on the hospital grounds. In May of 2012, he's allowed trips to the Selkirk community while accompanied by both a security guard and a hospital staff member. In May of 2013, those trips are permitted to extend outside of Selkirk. He's also allowed at this point to be on the hospital grounds without supervision, for gradually increasing lengths of time, starting with just 15 minutes. In February of 2014, he is permitted unsupervised trips within Selkirk and is moved to an unlocked part of the hospital. In February of 2017, Vince Lee had participated in all the rehabilitation programs offered, had experienced no further episodes of psychosis, and had continued to take the antipsychotic olanzapine.
If you were looking for a perfect record, this is a perfect record. Showing remorse, showing compliance, showing insight, not having relapse.
He was therefore granted an unconditional or absolute discharge. There will be no record of his offense that follows him, and no specific legal requirement to check in, to take his medications, and his rights and legal history will be as though the event did not occur.
Well, Mr. Speaker, the issue, though, is bigger than that, because we know that the Prime Minister voted against our legislation that was triggered by Tim McLean's death that would make sure that people like Vince Lee would not be allowed out. Right. So when the Minister and the Prime Minister looks at reforming the justice system, it's not about the rights of criminals that we're concerned about on this side of the House, Mr. Speaker. We think if people do this, they lose a lot of their rights.
Well, I could spend some time arguing that the good we do by granting Mr. Lee, now Will Baker, mercy outweighs the unlikely harm we risk should he go off his olanzapine and reoffend, I really feel that it's not for me to say. We would be unwise and callous as neighbors and fellow citizens to ignore the fact that this man is also a victim of his disease. But we would also be unwise and irresponsible as stewards of society to ignore the fact that a justice system cannot be replaced by the risk assessments of psychiatrists. What I can offer is a simple debunking of a common statement made about the case. This quote: Baker was charged with second-degree murder but was found not criminally responsible for his actions because he was diagnosed with schizophrenia and hadn't been taking his medications. This quote implies that Mr. Lee was somehow responsible for not taking medications before he knew he needed medication. Here is the story of September 3rd, 2005, nearly 3 years before the Greyhound incident. It is the one and only time before the Greyhound incident that Vince Lee encountered any kind of psychiatric care. Quote, he had been in Canada for 4 years and had no friends, no family, and no support system. His wife did not understand that he was experiencing emerging symptoms of psychosis, and the two of them became disconnected. Vince knew that a childhood friend from his hometown in China had moved to Toronto. So, at the direction of the voice he was attributing to God, Vince went to Toronto to connect with his childhood friend. When Vince got to Toronto, he did not know how to find his friend. He was experiencing intense symptoms and was completely immersed in a distorted reality that was dictated by his psychotic symptoms. He had spent all his money by this time and turned again to the voices for direction. The voice told him to go to the airport, as someone there would help him return to Winnipeg. After spending hours asking strangers for money at the airport without success, he was directed by the voice to simply walk back to Winnipeg. After 2 hours of walking down Highway 427, he was picked up by an ambulance and taken to hospital. Vince's memory of this time in hospital is vague. He recalls receiving 1 injection, sleeping for 2 days, and then escaping from the hospital. Documentation from the hospital paints a different picture. Vince was hospitalized at the William Osler Health Center in Etobicoke Hospital campus from September 3, 2005 to September 13, 2005. He had been brought to hospital by police officers involuntarily after he was found walking on Highway 427. Vince maintains that he was aggressive with staff upon admission to hospital due to the fact that he was receiving information via hallucinations instructing him that the staff were somehow intending to harm his wife. Vince was described as disheveled, confused, and unable to talk. They also describe him as vague, seemed to be hallucinating, staring into space. He was talking occasionally and asking staff not to hurt him. He was unable to give any history. He had not slept or eaten well for the past 3 days. Based on his presentation that day in Etobicoke, he was diagnosed with schizophrenia catatonic state. Despite the description of the severity of Vince's symptoms, he was hospitalized for a relatively brief 10-day admission. During that brief stay, he was treated with multiple medications, initially to address psychotic agitation, including intramuscular olanzapine, intramuscular clopixyl acufase, as well as oral risperidol at a dosage of 2 milligrams 3 times a day. After a few days in hospital, an antidepressant agent, Celexa, was added at the dosage of 20 milligrams per day. The day before discharge, he was started on Epival, a mood stabilizer, at 500 milligrams twice a day. Vince reports that he did not understand why he was in hospital. He believed he was being punished, and he had no understanding of any of the 5 different medications that he'd been started on during his brief 10-day admission. According to documentation, Vince requested discharge and, as such, was discharged against medical advice. According to Vince, he had no contact with mental health professionals after being discharged from hospital and took no medications from the time he left hospital in September of 2005 until that tragic day on July 30, 2008. Yes, he had not been taking medications. He also had no medications to take and no knowledge that this was required of him. This quote is at best lazy journalism and at worst intentional libeling of Vince Lee. To give us a bit more variety beyond the Vince Lee case, here are 2 others with different results. Glenn Race, at the age of 26, left his native Nova Scotia and killed several individuals in a string of murders from Halifax to the Mexican border. It was established that he had experienced paranoid schizophrenia from a young age, and that he believed he was receiving instruction from God to kill vampires and demons. This first branch NCRMD defense was successful in Halifax, but he is not in a psychiatric facility in Canada because, in New York State, the court sentenced him to life with no chance of parole.
He will remain incarcerated in New York State for the rest or remainder of his life.
I thought all kinds of people had to die, and in fact, when I viewed the world as a living example of its fate and how society was just perpetuating this overpopulation and globalized pollution that just kept escalating and escalating, I sort of predicted that if man didn't somehow cull the population or try to level it somehow, it would just escalate into almost an apocalypse. And I may have been the only person to do it because I was God itself.
Do you still believe that you had to kill those people?
Not exactly, of course not. Of course not. I come to terms with that, and I think it's not going to help anything really. You know, you could kill all the terrorists in the world, and still it's not going to really free the future of the calamity of what's going to happen. You know, it's difficult to say regret is an absolute thing on my mind, except that I live with the burden of imprisonment, which has been, over the past 8 years, a constant burden, a constant obstruction to my freedom, so much physically, mentally, and spiritually. That could be known as what regret is. Changing the past has a number of repercussions that could lead to a betterment of life for people, but in a lot of ways, there is a destiny, and it's being fulfilled. My heart is a very pure heart. I would say it's pure. I mean, it's not evil in any sort. You know, killing is not always evil, especially since, you know, you can't always say everyone who kills anything is evil. I guess it all comes down to how you judge people and who they actually are. But I'm not a bad guy.
And finally, just to demonstrate that in Canada diagnoses are not enough, for the case of Elaine Campion, the defense argued was that she was in such a state as to think that her murdering her 2 children was justified. In other words, they went with a second branch defense. She did not know what she was doing was wrong. The court ruled that her thinking it was justifiable is not the same as her being incapable of knowing that the rest of society would deem killing the children to be wrong. Justification is not lack of knowledge. She could have made the right choice and not acted in accordance with her justifications, but rather in accordance with societal standards. Some final perspectives on guilt and the finding of not criminally responsible on account of mental disorder. The first is the notion that determinism will both eliminate the idea of the need for punishment and bring with it universal forgiveness. While this sounds great in the light of psychosis, I challenge you to apply this to psychopathy. Some perspectives on psychopathy. Blair says that having a psychopathic brain does not excuse any specific behaviors. It's not like psychosis where one is disconnected from reality. The knowledge and analytical appreciation is intact in antisocial PD and its psychopathic extreme. Robert Hare just wants us to stop asking him, and Manuel Vargas best captures my feelings on the issue. In some sense, we have a justice system because of psychopathy. The more we strengthen the case for the harm blindness of individuals with psychopathy, their constitutional inability to appreciate the rights and intrinsic value of others, the more we also strengthen the case for keeping them away from society, for putting them on ice floes so we can continue to build a kinder social world. Finally, a man who is so skeptical of psychiatry that he actually teamed up with the Church of Scientology, Thomas Sass. Maybe, contrary to what Beatrice Maidman and the neuroscientists are arguing for, the solution to judges and juries making the wrong calls in NCRMD cases lies not in bringing more determinism into incompatibilist or free will frameworks, but rather in freeing these judges and jury members from having to navigate the dueling experts and technicalities and giving them leave to apply mercy and compassion case by case. Outsourcing the mind-reading, perspective-taking, and empathizing of judges and juries to a quote-unquote medical standard seems to be against the idea of juries. Being merciful or merciless toward lawbreakers is a moral and legal matter, unrelated to the actual or alleged expertise of medical and mental health professionals. In conclusion, hopefully there is enough in this lecture and in this course more generally to allow all of us to come to our own broadly informed conclusions, which will differ between us, which will within each of us vary, and which will, by virtue of varying, result in some conclusions that happen to be abnormal. And hopefully, we're okay with that. We'll see you next time.